Hello, everybody. My name is Timothy Scott, or TJ Scott, and I am the owner of the law office of Timothy J. Scott. I'm an estate planning attorney, and what that really means is that I help people get their affairs in order so that the people they love are protected um, when they can't be there to take care of them and really protect them and see them through. I'm so happy to have you here with me today. We are going to be talking about a subject today that I know is pretty tough, talking about death. Talking about what happens if we become incapacitated is a really difficult topic. And I know that. But I also believe that having knowledge is really empowering. And that's what I want to do here today. I really want to give you the knowledge so that you can feel empowered to tackle this important topic without having to be afraid of it. Because having the knowledge will allow you to do that. So let's dive in. First, um, you've reserved this time here to be with me tonight, to learn about estate planning and to learn about getting your affairs in order. And the best way to learn is really to be present with me here. And so if you have another tab open, I encourage you to close it. I can't see if you have another tab open or anything like that. But I just really encourage you to turn off the distractions. You've already set aside this time for yourself to be here and to learn with me. So please just give yourself this time. And I always say your future self is really going to be glad that you took the time to learn this here today. Again, if you stick around until the end, I have some bonus gifts that I want to give you. And the first gift is a free virtual one-on-one meeting with me, where we'll talk about everything that you have and everyone that you love and how you can protect everyone that you love and make sure that they receive everything that you want them to have. Plus, I have another bonus gift that's going to make it even easier to get a personalized and custom tailored estate plan in place for the people that you love. But before we get too far here, I'd like to find out from the audience, and I'm going to launch a poll. Do you have an estate plan? And so I have listed on the screen a few different things. I have a trust, will, guardianship, nomination, healthcare directive, power of attorney, beneficiary designations. And really, these are all parts of an estate plan. A well-written estate plan generally should have all of these things. Sometimes it won't have a trust, but generally it will have a trust. And we'll talk about that tonight and why that is. Guardianship nomination applies to if you have minor children, and it's something that's really important for parents with minor children that they have that guardianship nomination in place. So I'm looking here, it looks like more people do not have an estate plan than do have an estate plan. And that's fine. Whatever brings you here today, you're in a good place. In fact, if you don't have an estate plan, you're not alone. 69% of people in America don't have an estate plan. But I'd like to find out, why is it that you don't have an estate plan? And I've launched another poll. We've got a few of these. And again, if you want to share in the chat, you're welcome to do that as well. But one of the biggest reasons that I hear for people not having an estate plan in place is that they're too busy. And I totally get it. As a parent of three, life is really busy. But if that's the case, I just want to commend you for being here tonight and really taking this opportunity to educate yourself and get started on that next step, on that step of getting an estate plan in place. Maybe you feel like you're too young, and anyone over the age of 18 really should have something of an estate plan in place. I recently helped a young family who, a young father passed away and unfortunately left behind something of a mess for his wife and his two kids, his two minor daughters. But it doesn't have to be the case. You can get an estate plan in place, and you can get an estate plan in place as long as you're older than 18. Maybe you think that estate planning is too expensive, and I'm seeing a lot of people say that estate planning just seems like it's too expensive. And I'll tell you, before word processing, that kind of was the case. Before word processing, you used to have to fill in estate planning documents in triplicate. And if you made a tiny little mistake, you had to tear the entire thing up and start fresh. But today, we have word processors, and estate planning is really for everybody. And in fact, again, I'm going to show you some bonuses at the end that are going to make it even more affordable to get a great estate plan in place for yourself. Maybe you're worried about jinxing yourself, and I'm not seeing anybody say that they're worried about jinxing themselves, but it's something that I've heard before. And I can tell you, as somebody who's done dozens of estate plans in my time, I've never seen a correlation between somebody getting an estate plan done and having something happen in their lives. In fact, I always say, I think my clients seem to live more intentionally. It's like they have a weight lifted off their shoulders when they get their estate plan done. And so they enjoy their lives more and get more meaning from it. So thanks again for your responses in the poll. If you do have an estate plan in place, is there something in particular that you want to learn here tonight? And you can choose multiple items here. And in fact, if you don't have an estate plan in place, but something here really resonates with you, go ahead and let me know that. Or let me know in the chat if the reason that you're here tonight, the reason that you want to learn with me tonight is something else. So maybe you want to know if an online will is going to be okay. Or maybe you've done an estate plan in the past. Maybe you had minor kids at the time, or maybe you didn't have any kids, or not as many kids as you have now. And you want to know, is that plan outdated? Do I need to do something? Do I need to update it? Maybe you just want to get a better understanding of what that estate plan was. Maybe the attorney didn't describe it very well to you or in very much detail. Maybe that estate planning attorney didn't give you the knowledge that you really needed to have to feel empowered and to feel like you knew what was going on in your estate plan and you knew what was going to happen to the people that you love when you weren't there with them. Again, post in the chat if you have something specific that I can answer today, and I'll make sure to get to it. Seeing a lot of people say that they want to understand their own plan better. And maybe they mean a plan that they've done themselves, or maybe they mean the state's plan for them, because the state does have an estate plan for everyone. I do see some people also asking, is an online will okay? Is my plan outdated? And I promise we'll get to all of those things. I want you to know that you are in the right place wherever you're coming from right now. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you did an online will or a fill in the blank will, and you're not sure if it's going to work for you. Those fill in the blank wills, I don't see a lot of them anymore, but used to be that you could go down to the community center and every once in a while they would host an event where people could do fill in the blank wills. It's really interesting seeing some of those. And I can definitely speak to that. And you're in the right place if you're nervous about how much this is going to cost. I really understand. And I promise you that I'm going to talk about how much an estate plan should cost and how much you can expect it to cost. But the reality is that estate planning is not about you. It's really about the people that you love. And this became really clear for my wife and I when we were recently updating our estate plan. And those 3 kids, those are my kids right there. So from left to right, that's Margaret, Ben, and Elizabeth. Margaret is 4 years old. She just turned 4. Ben is 9, and Elizabeth is 6. And it is so important. It felt so good to get a plan in place and to know what was going to happen for them and to know that it was exactly what we wished to have happen for them. The people that we wanted to raise those kids were going to raise them. They were going to have the money and the assets that they needed in order to do the things that we hope for them in their lives and that we would want them to have the opportunities to do. And so even though my wife and I are never really going to get to enjoy our estate plan, we're never going to be wealthier because we've done an estate plan. Really, we have the comfort and the joy of knowing that that if anything happens to us, they're going to be well cared for. So what am I going to cover today? Well, we're going to talk about a lot of things today. We're going to talk about planning for incapacity. We're going to talk about who can make healthcare decisions for you or financial decisions for you if something happened and you couldn't make those decisions for yourself. Maybe it's because of dementia, maybe it's because of a coma, whatever the reason, if you became incapacitated, who could make those kinds of decisions for you? We're also going to talk about planning for when you pass away. And I think that's what most people think of when they think about doing estate planning. And so we're going to talk about guardianship. In fact, I should ask the question right now and see if there are people with young children in attendance tonight. Generally, there are some. But if you have minor kids, we're going to talk about guardianship and how important it is to get the right guardians named for those children. We're also going to talk about probate, and we're going to talk about the time, cost, and public nature of probate and what probate really looks like. We're going to talk about estate taxes today, and at least there, I have some good news for you, because most people right now are not subject to estate tax, and I'll tell you exactly why that is. We're also going to talk about unclaimed property. And this is something that you won't hear a lot of estate planning attorneys talk about, but I think this is so important. Right now, you're not going to believe the amount that is in the departments of unclaimed property across the nation. And I'm going to tell you how that money gets there and how you can avoid having your money end up in those departments of unclaimed property. We're also going to talk about your intangible assets, things like your stories and values, and how you can plan to pass those on to the people that you love when you aren't with them anymore. But I'm going to go ahead and end this poll. It looks like there are some people with young kids here. It looks like there are some people with grown kids as well. And again, I just really appreciate you sharing that with me. Again, if you have any questions or any comments or anything at all, I'd really appreciate if you'd post them in the chat. And actually, this is a really good time. So this is my family. We live in Bloomington, Minnesota. If you could let me know in the chat box, where are you coming here from? Where are you viewing this from right now? I'd really appreciate knowing. So my wife's name is Tobin, and my kids are Ben, Elizabeth, and Margaret. And again, it's Elizabeth all the way on the left, Margaret in the middle, and Ben on the right. And they are my whole world. So I graduated from the University of St. Thomas School of Law in 2012, near the top of my class. And the very next day, my first child, Ben, was born. And you can see the dates there. I just celebrated my 9-year commencement anniversary, and my son just celebrated his 9th birthday, which was really exciting. Right out of law school, I found a job with a small estate planning and tax preparation law firm. And I loved the clients that I was able to work with because they were focused on their families. They were focused on the people that they loved and really taking care of those people that they loved. But at the same time, I didn't always feel like I was providing the amount of value that my clients deserved. And so a little over 3 years at that law firm, I ended up leaving. And this is actually a picture of my last day there. Someone has to graduate at the bottom of the class. This was not said about me, but this was something that has really stayed with me. My parents had an extremely negative experience with an estate planning attorney who helped my grandmother before she passed away. And I remember my parents saying this to me: someone has to graduate at the bottom of the class. I actually don't think that attorney graduated at the bottom of the class, but I think that he was really planning under kind of a broken model of estate planning. And that's something that I want to talk to you about today, that there are different models of estate planning. And some of those models are just expensive and they don't take care of you the best way. But I really have developed a different model, something that makes sure that my clients are well cared for. And I'm seeing people from all over. I'm seeing Elko, Rosemont, St. Paul, fantastic. And I have somebody sharing with me. I have a 20-year-old son and a 16-year-old daughter who's autistic. And we'll definitely talk about that. And we'll talk about if you might need a supplemental needs trust, what that would look like, and why that might be something that you want. So I know not everybody here has minor children, but I want to touch on probably the most important issue for parents with minor children. And so even if you don't have minor kids, you probably know somebody who does, some family member or some friend who has minor kids, and you might want to share this with them. So what would happen if you left your kids, your minor kids, with a babysitter, and you went out and you had a wonderful date? You didn't have a plan in place, and for whatever reason, you didn't make it home that night. And I can tell you what would happen is the police would eventually get called to the house when you didn't show up, and they would have to involve Child Protective Services. And depending on the circumstances, your kids might end up having to go and stay with Child Protective Services. And I'm not saying this to rag on them, but honestly, I wouldn't want my kids to have to go and stay with Child Protective Services for even a moment of time. It's just not a place where I think my kids would thrive. I think it would be harmful to them. And so planning for short-term guardianship, planning for somebody who can take over from the babysitter, even if it's 9:30 at night, even if it's midnight, and at least be with those kids for a day or 2 days or whatever it requires before you can contact the long-term guardians is so important. It's such a vital part of guardianship planning. And so that's short-term guardianship, is who is going to stay with my kids for 24 hours, 48 hours, maybe a week, until my long-term guardians can get in place and take custody of those kids. It is so important, and it's something that most estate planning attorneys don't address. So again, if you know somebody with minor kids, this is really vital. Long-term guardianship is who is going to raise your kids until they're 18. And if you don't have a plan in place, there is a plan that exists for you. It's the state's plan, and that plan is that a judge is going to decide. It's probably a decision that you're not going to like. You know your kids, you know where they belong, you know where they're going to thrive, and you know who's going to really nurture your kids in the best way. And my guess is that it's probably not Uncle Larry. And maybe it's not Uncle Larry in your family that you don't want the kids to stay with. Maybe it's somebody else. But we all know somebody like Uncle Larry that we wouldn't want to have our kids, even if maybe that person looks like they're the best person to take the kids on paper. And so it's really important to get a plan in place and to make sure that your plan is legally documented so that the person who takes your kids, the person who raises them until they're 18, is somebody who's really going to nurture them in the way that you would want them nurtured. So let's talk about the people that you love and how they're going to receive your assets under either your current plan or the state's plan for you. And the state does have a plan for you. Again, that state plan is called probate. And this is what it looks like. Probate is slow. In Minnesota, probate takes at least 6 to 12 months, more often 12 to 18 months to get through. And it's kind of built that way. Probate is really for your creditors. As you can see down there in the bottom, probate is really a lawsuit that you file against yourself with your own money for the benefit of your creditors. Your creditors want to make sure that they get paid. And so they want a long time to be able to come forward and make their claims against your estate to make sure that they get paid. And so it's built in this way that you have to give notice to your creditors, you have to provide a public notice, and that your creditors have a certain amount of time that they can wait, that they can decide to come forward. I see somebody, will you be sending out the presentation? This is a great slide. I'm not going to be sending out the PowerPoint, but if you want a specific slide like this, I hope that you'll reach out to me and I can send you a screen grab of this slide. I'd be really happy to do that. Probate is also very costly. There are attorney's fees, executor's fees, appraiser's fees, court filing fees, all kinds of different fees, and they just add up. Probate in Minnesota costs anywhere between 3 to 6% of your gross estate, of the gross value of your estate. So you can imagine if you own a house that's worth $400,000, probate right there is going to probably cost somewhere between $12,000 and $24,000 to get that house through probate. And another piece of kind of bad news that I have to break is that a lot of people think that a will is going to help them avoid probate. Unfortunately, a will does not avoid probate. And there's this really nerdy phrase in the estate planning world, where there's a will, there's a probate. Sorry that I inflicted that upon all of you, but that's the saying, is where there's a will, there's a probate. And so any estate plan that is built on and focused on a will is going to have a probate. But there is a way that you can avoid probate. There's a foolproof way, a failure-proof way to avoid probate. And we're going to talk about that in just a second. Before we talk about that though, probate is also public. So right here, I'm showing you the last will and testament of Anna Nicole Smith. And wills are totally public. She had to file this, well, her family had to file this in the probate court and expose for everybody exactly who she had that was going to receive from her estate and what assets and what distributions they were going to receive. And that might not seem too bad. I mean, who's interested in going down and combing through all of the wills at the probate court, right? But there are bad people out there, and we all know that. And there are predators who are looking for prey, and they're looking for people who maybe have just inherited a bunch of money and they're young and they don't know what to do with it. And unfortunately, those predators are very real. And so having to file your will down at the probate court, along with an inventory and a final accounting that shows exactly what has been distributed out from your estate, is a lot of information to be giving people who may not have the people that you love, their best interests at heart. Worst of all, your kids would be entitled to receive all of your assets outright and without any restriction at 18. Again, I know that not everybody here has minor kids, but this is sobering. Maybe you have grandkids, and if something happened to one of your children and those grandkids stood in their stead to receive, they'd be able to receive at 18. And I can tell you, I know exactly what I would have done at 18 with an inheritance. I was a pretty mature 18-year-old, but I can tell you, I would have bought a Corvette and I would have driven really fast. And that money would have been gone. That money that could have been used towards something like my education or my wedding, or buying my first house. I would have spent it frivolously. I know I would have. I would have made mistakes because I was 18 years old, and an 18-year-old is really still a kid and shouldn't be receiving that kind of money. So I think we all have stories about young people receiving money that is really sobering. So now we have an opportunity to calculate exactly what the cost of probate might be for you. And this here is a sample probate estate. I know that it may not apply to everybody. I know that it might be more money than some people. It might be less money than some people, but this is just an example. This is just an illustration. So you can see here, I've included things like the family home. I've included a rental property, furniture and household goods, automobiles, stocks and bonds, and even a business interest there. And all of those things would have to go through probate. They're all probatable assets. And so if you want to get 5% of a number really quickly, this is a really cool trick. You just move the comma over one place. Oh my goodness. You just move the comma over one place. So in this case, you have 850,000. You move the comma over to the left. That's 85,000. You divide that number in half, which is $42,500, which is how I got the estimated probate costs and fees that are shown at the right. So that's expensive. But if you add in some life insurance and retirement accounts that are payable to a minor, because again, a minor can't receive, if they're under the age of 18, they can't receive and hold on to those assets. Somebody else is going to have to be found to hold those assets for them. And that means that they're going to be subject to probate. And so if they have to go through probate as well, that $1.5 million in assets that are payable to a minor, you can see how all of a sudden those estimated probate costs and fees really skyrocket. Again, probate is really expensive, but probate can be avoided. And again, there's a foolproof, failure-proof way to avoid probate, and that's by fully funding something called a living trust. And what a living trust is, it's a document that a lawyer writes, and it's really an agreement. It's an agreement between yourself and three different parties. So you are the person creating the trust, you are the person who is controlling the trust, and you're also the person who is able during your lifetime to benefit from the trust. You're also able to list beneficiaries who are going to receive later on after you can no longer receive, maybe even if you become incapacitated, who you would want to receive those assets. But really that's the key thing, is you're the creator of the trust, you're the person who has control of it, and you're also the person who has all of the right to benefit from it during your life. And that's what a living trust is. It's like I say, it's an agreement. And so you write this living trust, and then you fund that living trust by putting your different assets into it. So you're going to retitle investment accounts into the name of the trust. You're going to sign new signature cards at the bank. You're going to execute deeds on real property to put those pieces, those parcels of real property into the trust. You're going to transfer stock and bond certificates to the name of the trust, to the trustees' name of the trust. You're also going to assign personal property into the trust, and you're going to change life insurance and retirement account beneficiary designations so that they point to the trust. And doing all of that can really help, can make it so that you don't have anything in your gross estate. There's nothing left in your name when you pass away. Everything is titled in the name of your trust. And as long as that's true, as long as everything is titled in the name of your trust, you can avoid probate. You can avoid those 3 to 6% of the value of your gross estate. You can avoid the costs that you would incur from probate. You can avoid the time delay. You can avoid that slowdown where the people that you love can't take any distributions. They can't receive any money from your bank accounts. They can't receive any money from your brokerage or stock accounts, anything like that. They can't sell the house. Everything is just frozen for a time in probate. But instead of being frozen, with a trust, you can avoid that. You can avoid that freeze on all of your assets. So if somebody's reliant on you, if somebody is dependent on you providing for their rent, if somebody's dependent on you providing for their food or something like that, that they can still receive that those assets and still receive those distributions in order to pay for those kinds of things. And so that's why having a fully funded living trust is so important, and it is something that we can all do. So again, I told you with estate tax, I have some really good news. And the good news is this. Right now, the federal estate tax exemption is $11.7 million. And in fact, that number is actually doubled if you are currently married. And I think that's $23.4 million. And what that means is for your first $11,700,000, you pay zero in estate tax. Your $11,700,000 and first dollar, you would start to pay up to 40%, up to 40 cents on every dollar that is subject to estate tax. But again, that's great news. Most people don't do estate planning because they're worried about estate taxes. In fact, the number of people who are worried about the estate tax is very small compared to really everybody who needs an estate plan to take care of them. In Minnesota, there is also an estate tax that your estate might be subject to. In Minnesota, the exemption amount is $3 million. And so that means for your first $3 million, you pay nothing in estate taxes. For your $3 million in first dollar, you start paying at 13%, and you end up paying up to 16%. Again, I know that doesn't apply to a lot of people, but for the people that does apply to, I want you to know that there are great options for how you can plan for that estate tax and how you can minimize, most often you can even eliminate that estate tax. The number in Minnesota is not automatically doubled for married couples. And that's kind of a shock, but there is some planning that you have to do, and it is something that you can plan for, but you can double that number with a properly executed estate plan in place. And that's just some work that would have to happen. So here you can see an example estate tax, or an example estate that would be subject to estate tax in Minnesota, but again, wouldn't be subject to that federal estate tax, which is really the pecuniary or the really painful estate tax rate. Something to note, the laws may change on this. Right now, there are discussions to change certain things called the step up in basis, which is something that I'm really happy to talk about in detail. It's something I know a lot about, but is a little bit outside the purview of this webinar. So if you're interested in hearing more about the step up in basis, or if you're interested in hearing more about the lowering of the federal exemption to $3.5 million and what that might mean for you and your estate, or what that might mean for the Minnesota exemption and whether that Minnesota exemption is going to go down, I'm happy to talk about that. And I hope that you'll reach out to me so we can talk about that. Any idea how much money is in our state Department of Unclaimed Property, the Minnesota Department of Unclaimed Property? And I'll look over to chat here and see if anybody has a suggestion or a number that they are willing to take a guess at. I'm not seeing any guesses, not a clue, somebody says, which I totally understand. Right now in Minnesota, there's more than $700 million in the Minnesota Department of Unclaimed Property, 700 million. And across the United States, there's $58 billion in different departments of unclaimed property. And that's pretty shocking. A big part of how money ends up in those departments of unclaimed property is that somebody passes away and their heirs go through their mail and they look through all of the papers that person has, but something gets missed. And maybe it's some stock that that person purchased a while ago and they lost the stock certificates. Maybe it is a bank account that that people weren't aware that they had opened. Maybe they didn't even remember that they opened it because they'd opened it 10 years ago or 20 years ago. Whatever the case, right now, again, across the United States, there's $58 billion in departments of unclaimed property. And again, a big part of that is just not having everything organized, not having everything organized into an inventory to make sure that everything gets to the people that you want it to go to. I'm young, and I have 3 kids, and I haven't amassed the amount of wealth that maybe I dream of. Right? I don't have that much that I'm going to be passing on to my kids right now. And so I can tell you it is even more important to me as somebody who doesn't have millions upon millions of dollars that are going to be going to my kids. It's even more important to me that I make sure everything that I have does go to my kids, that nothing gets lost. And again, this is something that not a lot of estate planning attorneys address, but it is something I think is so vital to making sure that your estate plan is a success, is that nothing is getting lost. Nothing is going into those departments of unclaimed property. And it's something that I address in the planning that I do. And I make sure that I take care of for my clients so that nothing is lost for them and nothing is lost for their heirs. This is really cool. You can make your estate plan a real gift to your children by building in something called asset protection. And asset protection means that their inheritance can be protected so that it can never be taken away by a spouse in divorce. It can't even be touched by if something happens and your child is in a car accident, for example, and there's a settlement or a lawsuit against them, and there's a judgment against them. You can make it so that their inheritance is free from that lawsuit and is not subject to a divorce and to a divorce decree. And so if that sounds like something that you'd be interested in, I hope that you'll reach out to me. It is something that is really cool. And I love being able to help my clients to build this into their estate plan to make sure that their kids or whoever they want to receive is taken care of as well as possible. Planning for incapacity. Now, this is something that I know is really real for a lot of people. A lot of people are concerned about incapacity, and you may recognize the person on the screen depicted here. This is Terry Schiavo. And Terry Schiavo, there was a big case about Terry down in Florida and about whether Terry should continue to be on respirators, whether she should continue to receive nourishment through a feeding tube, or whether Terry should be let go. And there was a big argument between her husband, who thought that Terry wouldn't want to live this way, that Terry would want to just be let go, would not want to be sustained this way, and her parents, who thought that Terry would want to be kept alive at all costs, no matter what it cost her, what it cost the family, that Terry would want to continue to live. And this is something that, again, I know is really real for a lot of people right now. And a lot of people have feelings about what they would want and what they would want for their family and what they would want communicated to their family, and also who they would want making those decisions for them. But if you haven't taken the time to put those things down in a healthcare directive, it's not a sure thing that they're going to be, that those wishes are going to be honored when you want them to be honored. I think that was the case with Terry. Is two people were arguing diametrically opposed positions, and even though Terry had put down who she wanted to make healthcare decisions for her husband, she didn't communicate what those decisions would look like. And so, because she hadn't said what those decisions would look like, it led to a lot of conflict, led to a lot of court, and a lot of hurt across the entire nation. So, what can you do today to do the right thing for your family, and what should it cost to plan right? And really, the options that you have to create a plan are to either do it yourself or to work with a lawyer. And please keep in mind, not all lawyers are the same. So how do you choose? Would you benefit from working with a lawyer? And if you own more than just your personal belongings, if you own a house, if you own a brokerage account with significant money in it, or a bank account with money in it, you would probably benefit from working with a lawyer. If all you own are things like cars, clothes, jewelry, furnishings, and the clothes on your back, then you could probably do it yourself. But if you have assets outside of that, if you have a home, just having a home in and of itself means that you should probably work with a lawyer and make sure that you get an estate plan that you know is going to work for you when you need it to work. If you want to ensure that the people that you love stay out of court and conflict and have someone to turn to when something happens to you, then you should really work with a lawyer to make sure that they are going to be well taken care of when you can't be there to take care of them. If you want a kids protection plan, which includes a short-term guardianship, long-term guardianship, as well as guidance documents for those guardians, and guidance on what kind of medical and healthcare things that they should take into account, then you really need to work with an attorney. If you want to avoid probate, or if you think that you might be subject to estate taxes, then you really need to work with an attorney. Or if you want to protect your children's inheritance in something like an asset protection trust so that it can't be taken away by a divorcing spouse or taken away by creditors from something like a lawsuit, then you really need to work with a lawyer. And if you want to guarantee that your plan is going to work when your family needs it, then you have to work with a lawyer. I've seen a lot of people do it themselves. I've had people come to me for probate consults where they tried to do the plan themselves, but they forgot to record a deed, or they forgot to go down and change an account to the name of the trust, or they didn't write a trust. They thought a will was going to help them avoid probate. There are so many mistakes that can be made, and it's heartbreaking when you see it. And it's heartbreaking when you know what that family is going to have to go through for the next 12 to 18 months, just because they made a little mistake. But it happens with do-it-yourself plans. If you want to give your assets to someone other than your kids, I added this in right there at the bottom. You can see it's really important that you work with a lawyer. If you want your assets to go by some other way than intestate succession, some other way than the state would already have them go, it's really vital that you work with a lawyer to make sure that that's written the right way. So now you probably know whether or not you want to work with an attorney, but how do you choose that attorney? So I talked about this earlier. I referenced what my parents said about that attorney who helped to plan my grandmother's estate. Someone has to graduate at the bottom of the class. And again, this was not said about me. This was said about another attorney. And in fact, I think their frustration, again, wasn't about how much the attorney knew or how intelligent that attorney was. I think that attorney was just working under a faulty model, a broken model of estate planning, and they were trying to make it work, but it was a very traditional model of estate planning that didn't take into account the things that they needed to take into account to really take care of my family in the best way. So here's what that looks like. Here's what I call it: planning for death. It's the typical experience that you would get when you work with an estate planning attorney. In a typical experience, you're going to get form documents that are kind of just set it and forget it. The lawyer sizes you up when you walk into their room. They pull out some form documents that they know that they're going to work on, and they don't really pull them out, but they pull them up in a Word document, and they do Control F, and they just replace your name in a bunch of places where it says to fill out your name. They're not really tailored to you. They are just form documents that they fill your name in on. And after they've created those documents for you and helped you to execute them, they don't follow up with you. And so when something changes down the road and a new baby is born, or you move and you get a new house, they don't follow up with you. And you forget about it and they forget about it. And when it comes time that your estate plan is really needed, it's been forgotten and it's outdated and it isn't going to do what you want it to do. The typical experience doesn't keep money out of the Minnesota Department of Unclaimed Property. Again, it's just not something that a typical estate planning attorney is worried about. It's not something that they think that they need to be focused on. Typical experience might avoid probate, but it might not. Some estate planning attorneys will tell you that it's impossible to avoid probate, that every time that they try and write a plan, it just ends up going to probate. And I can tell you that might be true for other attorneys, but it's not true for me. And it's not true for the model that I'm practicing under. You can avoid probate, but it takes real hands-on care from your attorney. It takes personal relationship with your attorney to work through and make sure that your plan is really going to work and that it's really going to help your family to avoid probate so that they don't have to go through that heartache. A typical plan is probably not going to keep your family out of conflict. Typical plan is only going to focus on your money, not your stories, not your values, which I know matter more to a lot of people, that their kids receive their stories, that they receive their values, and that they learn from them, and that they really are enriched by them. Typical experience is going to leave assets to heirs unprotected. I'm kind of at a cutting edge in the type of asset protection that I'm doing. It's well founded, it's well documented and established, but a lot of attorneys are practicing the same way that they were 30 years ago or 40 years ago and aren't providing this asset protection to their clients. Typical experience isn't going to provide ongoing legal guidance, which I think is so important. Again, you can't just put your documents in the bottom drawer and forget about them. You have to update them, and we have to keep in constant communication to make sure that everything is as you would want it to be. Typical experience is going to charge hourly fees for future needs. And that's just the way that it works. You call them up and you ask them something simple like, what was the name of my trust that we created together? And 2 weeks later, you get a bill in the mail. My managing attorney at the small estate planning law firm that I was working at was charging $400 an hour, and my rate wasn't far off of that. So you can imagine if all you do is have a 30-second call with a lawyer, with your lawyer, you'd be getting billed either a quarter of an hour, $100, or you'd be getting billed a tenth of an hour, depending on how that attorney charged, and you'd be seeing that bill in the mail 2 weeks down the road. Typical experience also isn't going to adequately protect the kids. Again, most estate planning attorneys don't do short-term guardianship nominations. It's just not something that they have thought to do, but it is so important to get that in place to make sure that Child Protective Services aren't taking your kids for any amount of time. And it's really going to leave you in that typical estate planning experience. It's going to leave you with this question: will this work when I need it to work? And that's not a question that you should ever have when you work with an estate planning attorney. The way that I work is totally different. It's a completely different experience from that typical estate planning experience. The way that I work, you have flat fees and you choose the fee. And that doesn't mean that I'm going to rely on your benevolence in order to pay me something. I'm going to lay out options for you, and you can choose the option that you know is going to be best for your family. And I'll help guide, I'll help counsel, but I'm not going to choose the plan for you. You're going to choose it based on what you know would be best for your family. Planning with me means keeping your money out of the hands of the state. Again, this isn't something that most estate planning attorneys do, but it is so important that everything get to the people that you want it to get to, and I can help with that. Planning with me means protecting your kids totally, in the immediate and in the long term. Again, I know not everybody has minor kids here, but you can imagine how important that is if you do have minor kids, making sure that they are protected totally. Planning with me means keeping your family out of court and conflict. It means knowing that you've made the right decisions, because I'm going to educate you. I'm going to empower you so that you know that the decisions that you've made are exactly what's right for your family. And you know exactly what's going to be happening for your family. Planning with me means that you can protect the family money from outsiders, from people like that divorcing spouse who might want to take part of the inheritance that your child just received. It means protecting money from things like lawsuits and judgments against your children. Planning with me also means a lifetime of guidance and protection. And that means that you can reach out to me anytime. I charge, like I say, flat fees, and those flat fees include any calls that you make to me during our representation. It also includes future calls to me. And that doesn't mean that I'm going to update your plan for free whenever you need, because I don't know what your future holds. I mean, you might not know what your future holds. Who does these days, right? The future is a mystery, and we're going to have to see what happens down the road. But I can promise you that you're not going to get a bill in the mail for giving me a call and asking me what the name of your trust is, especially. And I'm not going to bill you when you call and tell me, great news, I just had my first grandchild born, or I just had another grandchild born, Or I just moved and I'm in a new house now. And what does this mean for my plan? And what do I need to do? I'm not going to charge you for those phone calls. I want to know. I want to have a relationship between us where you know that you can reach out to me and you could communicate those really important things to me. And I can communicate back and tell you exactly what that means. I can tell you what laws have changed and what that might mean for your estate plan. And we can have those conversations about what your estate plan does and what you want it to do. Planning with me means that you know that your plan is going to work when your family needs it. And really, again, it's a gift that you're giving to the people that you love the most. So I promised you, I'm going to talk to you about what the cost of putting a great estate plan in place is. But first, I want to just provide some context. Putting an estate plan in place with me means that if all that you have is a house that's worth $400,000, and I know that's a nice house, I know it's a pretty nice house, but if all that you have is that house that's worth $400,000, your family is going to be saving at least $12,000. That's 3%. And that falls, again, within that 3 to 6% of the gross value of your estate. That's what probate costs, is 3 to 6%. So if all you have is that $400,000 house, you're going to be saving $12,000 by getting an estate plan in place. If you have over $3 million in assets, then you're going to be saving 13 cents for every dollar above $3 million, all the way up to 16 cents for every dollar above $3 million. And if you're above $11.7 million, first of all, kudos. There aren't many of you out there. But then you're going to be saving over 40 cents for every dollar above 11.7 million. The typical death plan or the typical plan with an estate planning attorney is going to cost at a bare minimum $1,500. And you can be almost guaranteed that it's not going to do what you want it to do. First off, that attorney probably isn't going to take the time to educate you. They're probably not going to take the time to make sure that you fully fund a trust, if they're even writing one for $1,500, which they probably wouldn't. They would probably write a will and know that your plan is going to end up going through probate. And they might even count on that and collecting the fees, the attorney's fees that your estate would be subject to. But you know, it's almost guaranteed to not keep your family out of court in conflict. It's not going to keep your assets out of the State Department of Unclaimed Property. Again, in Minnesota, there's over $700 million in assets in the Minnesota Department of Unclaimed Property. And across the United States, it's something like $58 billion. And it's just being allowed to happen. But I don't allow it to happen to my clients. I think that that's really important, that the right people get your money, not the government, not the State Department of Unclaimed Property in particular. A typical plan is only going to cover your money. It's not going to cover your kids' immediate care. It's not going to pass along your values, insights, your stories, and experience. Those valuable, intangible assets are the most commonly lost assets. Or you can meet with me. I'm a personal family lawyer. And what that means is I have a special relationship with my clients where I work really closely with them. And you can learn specifically what your family needs and choose your own fee, likely to range somewhere between $2,000 and $8,000. And I can tell you, most people fall around $4,000. That's where most people's plans, when they plan with me, that's where it falls. And you know that your plan is going to work when your family needs it to work. And again, I want to make this really easy for you. I want to give you that initial meeting with me, that family wealth planning session, and we can even do it virtually. It's what the family wealth planning session is. It's a 2-hour-long working session where we'll talk about everything that you have and everyone that you love. And we'll talk about exactly what's going to happen. We'll talk about who might step up and try and find all of your assets and how successful they'll be in finding all of your assets. Or if you have electronic statements turned on somewhere and something might not be found, how to make sure that that person knows where to find those assets and gets access to them. We'll talk about incapacity and what incapacity looks like and what it means, and who could make decisions for you if you needed somebody to make healthcare decisions or financial decisions for you. And we'll talk about probate and what it might look like if your estate had to go through probate. We'll talk about exactly what that might cost your family, and we'll talk about what the time period would look like and what happens at each stage along the way. We'll also talk about what having a public probate might look like for your family. And if you have vulnerable people in your family, what that might happen, what might happen to them. It's not going to be a downer, I promise. It sounds like a real downer, but we'll talk about all of these things. And we'll talk about estate tax. We'll talk about asset protection and whether there are assets that you want to make sure that are protected, or whether you're okay with all of your assets going outright to the people that you love, if they're ready to take those assets, if they're ready to receive them. And I want to give you that family wealth planning session for absolutely free with me, because I just want to meet with you and talk through this with you. And if all that I get out of this is the satisfaction of knowing that now knowing that you are empowered and that you know exactly what's going to happen to your family. And if you're okay with the state's plan for you, or if you're okay with the either outdated plan that you have or the online will that you have, then I'll be happy at the end of the day, because I've provided a service, and I'm happy to know that you're happy with what's going to happen with your family. But if you want to do an estate plan with me, then I also want to give you $250 off the cost of that estate plan. And really, the reason that I want to give you that $250 off, if you will reserve that family wealth planning session before the end of the week, is because there's a certain momentum that happens when you are getting your estate plan in place. And you probably know exactly what I'm talking about, because maybe this is something that you've been thinking about for a while and you've kind of been procrastinating about it and you haven't really wanted to do it. And I completely understand that. There's a momentum. There's a forward movement that you can probably feel, where now is the time to seize the opportunity and to get this done. And if you let this opportunity pass by, maybe it's something that you'll think about again in a month or a year. But really, this momentum kind of comes and goes, and I can help you to get your estate plan done. I can help you along the way, and I can help motivate you and keep you moving in the right direction. But the first step that you have to take is booking that family wealth planning session with me. Again, a completely free meeting that I want to give you. So those are your next steps. Your next steps are to schedule a free family wealth planning session with me. Again, that 2-hour-long session where we'll go through everything that you have and everyone that you love. We'll talk about all those things that I talked about today, but we'll talk about them in regards to your specific situation. And we can really get clear. We can get a clear picture on what the state's plan is for you, and whether you're okay with that state plan, the state written plan, or whether you want to take control over that plan, and whether you want your family to have something different, whether you want it to look different for your family. And then in that family wealth planning session, use the $250 towards the plan of your choice. I'm going to look over here and see if I have any questions. I see somebody, and I'm not going to say the name but I appreciate you sharing that with me, that somebody had an experience with an attorney, and that attorney did not make sure that the parents' trust was funded correctly, and mom ended up having to go through probate. And I hate to hear that, because it's not necessary. That unfortunately, the way that a lot of estate planning firms work, they don't have the time and they don't have the energy to be able to dedicate their focus to helping to make sure that the trust is completely funded. And kind of a bad part, an unfortunate part of my industry, and lawyers, unfortunately, we have a bad reputation, and a lot of times we work really hard to deserve it. But in my industry, for that attorney, it probably was a good result for that attorney, because the trust didn't get funded, but the attorney was able to collect the fees for drafting a trust, right? I imagine that attorney was also able to help get your mom's estate through probate. And again, the cost of probate is something like 3 to 6% of the gross value of the estate. So not only was that attorney able to collect the fees for writing the trust, and probably writing something like a pour over will and some incapacity planning documents. But that attorney was probably able to collect the fees for your mom's probate. And that's a really unfortunate thing. I can tell you that is completely anathema to the way that I practice. When I practice, I take care of my clients, and I want to make sure that you are well cared for. I want to bring peace to your family. I want to help you avoid court and conflict. I'm sorry, I got really serious there, but it is so important. It is so important. I see here, can your gift toward planning be used by people who already have a plan or trust started, but may need help ensuring all properties and assets are correctly in the trust? And absolutely, that's a great question. You've come here tonight and you've put in the time to learn about this. And I really respect that, and I really honor that. And so I understand that you already have a plan done, you already have a trust done. I would love for you to schedule a family wealth planning session where we can review that plan, we can review that trust that's been written for you. And if everything is perfect, that's great. And if you just need help funding that trust, I am very happy to help. And I will apply the $250 towards funding that trust. I'm very happy to help you with that and to apply that money towards that. But I really encourage you to schedule the family wealth planning session with me and get really clear on if that plan is doing everything that you want it to. And maybe it is. I hope that it is. I hope that it is. Great. Some other questions that I have. Some people have asked about supplemental needs trust or special needs trusts. And I can tell you, if you know somebody who has special needs, if you know somebody who receives government benefits or might need to receive government benefits when they're no longer a minor or when they're old enough to be eligible for it, it is very important to have a supplemental needs trust in place for that person. If somebody gives money to that person, if they inherit money, inheriting that money might seem like a good thing, but it could actually knock them off of the government benefits that they have applied for and become eligible for. And what that might mean is, even though they have some money for a while, even though they have some money to pay for the things that they need, that money is going to dwindle and that money is going to be spent down. And what's going to happen at the end of it is they aren't going to have access to those government benefits until they go back and reapply for those government benefits and maybe wait in line, maybe wait for their application to process. It can take a long time and it can leave gaps in their coverage. And so having something like a supplemental needs trust can make sure that those assets are held and that that person is able to enjoy those assets for extra things that the government doesn't take care of for them. They're able to enjoy those assets without putting in jeopardy the government benefits that they qualify for. Other questions that I get, actually, I had a question recently, is somebody owned a manufactured home, or somebody owns a manufactured home, and they want to know what to do with this home. How do I take care of it? And it's a really good question. A manufactured home, if it's not affixed to the ground, is not considered real estate. If it's not on a parcel of land that the person owns, and it's not really considered real estate, it's more considered personal property. But there are things that you can do in order to make sure that that personal property is transferred on your death to the people that you want to receive it. And that's really important. One way to do that is with a trust, like I talked about earlier, but there are some other ways that we could explore. And so if that applies to you, or if you know somebody that applies to, I hope that you will come and set up a meeting with me so that we can take care of that for you. Another thing that I hear a lot about is I'm nervous about the cost of nursing home care. That the cost of nursing home care has gotten just skyrocket high. And it's something that I am worried about having to spend all of my money on and not having any money left for the people that I love, or just incidental things that I enjoy that I want to be able to afford in the future. And I can tell you that's a very real concern to a lot of people, with the cost of nursing home care just skyrocketing the way that it has and continuing to increase. And with certain care costing more than others, care like memory care. But it's also something that I am able to handle and that I'm able to advise on. There's something called Medicaid assistance planning or long-term care planning. And it's a part of my process. And it is something that I watch for, and it's something that we'll talk about in a family wealth planning session if it's a real concern of yours, and how we can address it and how we can take care of that for you. So you've probably already seen in the chat box, I've posted my booking link. And if you haven't taken the opportunity, I hope that you'll click through there. I understand some people have spouses that they need to coordinate with. If you're married, I hope that you will coordinate with your spouse and come together to the meeting, to our virtual family wealth planning session. But I hope that you'll click through and take a look at the times that I have available. And you can see we're getting towards the end of May. I have just a few more, maybe a couple more appointments that are available in May. I have some availability in June, but more availability in July. And that's just what happens is people book on a first come, first served basis. And I would love to have more availability to help everybody. But as I said, I really devote a lot of time and attention to every client that I have, and making sure that they are really well cared for and that their estate plan is going to take care of the people that they love when they need to be taken care of. So again, I hope that you'll click through to that link and make sure that you save it. Make sure that you save it in another tab. I am going to send out an email in just a little bit. And in that email, I'm going to include the link to book with me. Again, I promise to give you a free family wealth planning session and $250 towards a plan of your choice. So I really hope that you take advantage of that and either click through on the link right now and make sure that you save it in a window, or just go ahead and grab a time. If you need to reschedule that time, it's okay. You can reschedule that time. You can email me, you'll receive an email and it'll say exactly that. If this time no longer works for you, that's okay. Just reply to this email and we can find a time that does work better for you. But again, this is a momentum thing. Planning, estate planning is a momentum thing. And you've really got to take that step, and you've got to get the appointment booked so that you can continue on and get an estate plan in place that's going to take care of the people that you love. I'm not seeing any other questions come through, but if anybody has any additional questions, I'll wait here for just a minute and see if anything else comes through. Otherwise, I hope that you've learned something tonight. I hope that you've enjoyed as much as possible. And I'm going to go ahead and sign off now. So again, I hope that you had a good night. I really want to thank you for joining me. It's been a pleasure having you here and being able to share this knowledge with you. And I hope that I can serve you in the future. Take care.